What Supreme Court cases defined your rights during police stops? Imagine being pulled over by a police officer and wondering what they can and cannot do. Knowing your rights can make a big difference in how you handle the situation. Several important Supreme Court cases have shaped what you can expect and how to respond during police stops. These rulings protect your Fourth Amendment rights against unreasonable searches and seizures, and your Fifth Amendment rights against self-incrimination. The case of Terry v. Ohio in 1968 set the standard for stop and frisk procedures. The court decided that police can stop you and briefly pat you down if they have a reasonable suspicion that you're involved in criminal activity and might be armed. They do not need probable cause, just specific facts that make sense. This means if an officer suspects something, they can stop you temporarily for safety reasons. In 1966, the case of Miranda v. Arizona established that if you are taken into custody and questioned, police must tell you your rights. These include the right to remain silent and the right to have an attorney present. This protects you from being forced to answer questions that could incriminate you. Graham v. Connor in 1989 clarified how police use force during stops or arrests. The court said that any force used must be reasonable from the perspective of a typical officer on the scene. They consider the total situation, including how dangerous the circumstances are. Excessive force claims are judged under the Fourth Amendment, which guards against unreasonable seizures. In 1996, W.H. v. United States ruled that if police have a valid reason for stopping your vehicle, like a traffic violation, the stop is lawful, even if their real reason was to investigate other crimes. The officer's motive doesn't matter as long as there is an objective legal reason for the stop. The case of Arizona v. Johnson in 2009 confirmed that during a lawful traffic stop, officers can pat down passengers if they reasonably believe the person might be armed and dangerous. This is for officer safety, even if there's no suspicion of criminal activity. In 2021, Torres v. Madrid expanded what counts as a seizure. The court said that even if you physically escape police custody after they try to detain you, you are still considered seized if they used force to try to stop you. This means your rights are protected even if you manage to get away. Finally, in 1980, United States v. Mendenhall established the free-to-leave test. If a reasonable person would feel free to walk away under the circumstances, then no seizure has occurred. If they would not feel free to go, then your Fourth Amendment rights are involved, and you can challenge the stop. Knowing these cases helps you understand when police actions are lawful and when they might violate your rights. During a stop, you have the right to remain silent, refuse searches without a warrant or probable cause, and ask if you are free to leave. If you are detained, ask why and stay calm. If they conduct a pat-down, they must believe you are armed and dangerous. You also have the right to an attorney if you are questioned while in custody. If you think your rights are violated, do not resist. Instead, stay calm, document what happened, and seek legal help afterward. Being aware of these rulings can help you protect yourself and respond properly during police encounters.